Aloha, I'm Richard Emery, your host today for Condo Insider, Hawaii show about condominium living for both board members and owners. If you've been following this show at all, you'll see that a couple of times during the month we do interviews with experts and interested people in the industry. And once a month we do an educational program where you're stuck with me. So I'm going to talk about an interesting and important topic in the industry. Today, the topic is dispute resolution. And sometimes owners have disputes with their condo board, or condo boards have dispute with owners, or condo boards have dispute with other condo board members. And we're going to talk about all the possibilities within the condo statute to address this issue. It's a little bit timely because, as you may know, our legislature just adjourned from a short session, and the session was obviously shortened because of the COVID-19 issue, but 3 condo bills did pass out of the session, and I'm going to discuss them briefly. They're pretty ordinary in the sense that 2 bills dealt with priority of payment and dispute resolution. And essentially the current law, when it was adopted 2 years ago, had what we call a sunset provision, meaning that if in fact the legislature didn't delete the sunset provision, then in fact those laws would expire and no longer be in existence. Well, the legislature realized this and put it on their short calendar. So the 2 bills, one that extended the existing requirements on priority of payment that you can only foreclose for delinquent common assessments, and the expanded dispute resolution, both passed out of the legislature and have been enrolled to the governor. We expect him to sign it and the continued policy and practices go onwards. The other bill had to do with the biannual real estate fees or condo education fees all condos pay every other year in the state. The fund sits with about $2 million in it. And that particular bill gave the Real Estate Commission the right to have a moratorium or suspend those fees if in fact they felt that the fund, the $2 million, was adequate to sustain its educational and mediation requirements within the statute. Because that fund, frankly, has been growing every year, even though the Real Estate Commission does a good job in providing seminars and other topics and programs to support condo education and also support this mediation I'm going to talk about shortly. It's a good program, and both those bills did pass out of the legislature today or this week, and we're waiting for the governor to make a final decision, but I don't think they rise to the attention of anybody right now with all the problems we have in our state, like the budget. So anyway, let's set the framework about condominium living on a slide called self-governance. When you live in a condominium, you have to understand that condominiums are all varied in size and quantity and type and number of units, amenities, resident manager, no resident manager. And the whole principle within our statute is self-governance, that the people who live there elects a board of directors, and that board of directors will establish rules for the association in conjunction with having to comply with their declaration and their bylaws. And so you live in a condo, you're going to find different rules in different places and different locations. And a lot of times owners don't feel that the condo has done a really, really good job with respect to enforcing its rules, or maybe they feel they're being picked on or retaliated against. And so to understand the basic concept, you have to understand that condos basically govern themselves. There's very little restriction within the statute other than you have to comply with your declaration bylaws and state laws. So obviously discrimination would be a problem. You get into pets, that's a different issue because condo boards can restrict pets, but then they can't restrict service animals because the federal law allows people with disabilities to have service animals. And I'm going to intentionally avoid assistance animals or emotional support animals because that's another topic for another whole show. So let's talk about the types of dispute mechanisms you have available to you. And there's really basically 5 types of solutions within the condo statute that are available to you if you have a dispute. And the current law is basically designed around a concept, pay first, dispute later. And that applies pretty much to your maintenance fees. So if you have a dispute on, you don't want to pay your maintenance fees, you have late fees or legal fees regarding your maintenance fees, you have to pay first before you can dispute it. Other things like your house rule violations or the board's duties and things like that, you can mediate and you don't have to pay first. But the 5 choices you have, and I always start with number 1, is meet with the board. 2, what we call facilitative mediation. Number 3, evaluative mediation, which was established a couple of years ago under Act 187 and amended under Act 196. Then you have non-binding arbitration in the statute. Now, that's a weird thing, but I've seen it used a couple of times, and it has some very unique characteristics to it. And then the 5th choice you have is you can always go hire a lawyer, and they're not cheap, and file a claim or lawsuit and either end up into binding arbitration or litigation through a jury or a judge or through some other mechanism. What I would tell all of you is that when you get into a dispute, and it's about 50-50, the claims that are filed of the board versus the owner and the owner versus the board. Look at actual statistics issued by the Real Estate Commission. But the reality of it is, when you get these demand letters by the board, don't ignore them. So if they're telling you you're in violation, they start telling you that they find you, they start finding you more, then they send you a letter that they're going to take legal action and potentially foreclose on your property, which there's some special conditions on that. Don't stick it in your drawer and just say, screw you, I'm not going to do anything about it, because it's going to cost you money. You're going to put yourself in a bad situation. And if you have something you're upset about, you're better off dealing with it through one of the 5 mechanisms that we're going to talk about today. The mediating with the board is very simple. They hold board meetings regularly, and you would just send your board president or your property manager an email and say, look, we have this issue, and we have this fine, and we have this dog violation or parking violation. I would like to meet with the board at executive session. So you go to the board meeting, and you can, at the end of the meeting, when they hold an executive session, the board can meet with you privately and discuss your concerns and maybe come to an agreement, like, if you don't do it ever again, we'll waive the fine this time. Or I'm not saying don't do that, but it's certainly an option to them, because, you know, the purpose of fines is getting compliance. So I always recommend the boards that they, if it's a minor issue, that they say, okay, if you agree not to do it again, we'll suspend the fine for a year and waive it if you don't do it again within a year, and please don't do it again. Sometimes it's more complicated. Like, I have an association right now where an owner's decided to paint their door, front door, a different color. Well, the covenants prohibit that. So if that goes to fines and legal and lawyers, legal fees that are all charged to the owner, then in fact, the board may say, we'll waive the fine of $100 a day, but you have to pay the legal fees, because that's an out-of-pocket cost for all the other members of the association, and we're going to want to do that. But you certainly don't lose anything, and it costs you nothing to go try to have a meeting of the mind with the board. And understand why they have the rule, or why they find you, or why they're saying you're violating the governing documents. And that's probably the first choice. The second choice is the next slide, please, is what we call facilitative versus evaluative mediation. That's number 2 and number 3 choices. In the old days, since the beginning of the condominium law, the statute has provided that a board owner and a board member can go to mediation. In fact, that's a mandatory obligation. Under the statute, it's a breach of fiduciary duty if the board doesn't go to mediation. And if you had to sue them and file something in court to force them to go to mediation, it guarantees you the recovery of your legal fees. But facilitative mediation is an interesting type of mediation. Basically, you go to places such as the Mediation Center of the Pacific, $50 a person, and the mediator can't take sides. It's kind of like a kumbaya. This is how they feel. This is how I feel. This is why I want to have a second dog, whatever the issue may be. And the facilitated mediator tries to get both sides among themselves to voluntarily agree to a solution. And the solution may be you won't do it again. And it's very cheap. It's $50 by each person. I should say each side. So if you have multiple people involved, it's $50 per party, for lack of a better word. And it's okay for simple claims, because the mediator can't take sides, and he's just trying to talk both sides through it and try to find a path to a compromise or a resolution anyway. Evaluative mediation is what I said, Act 187, came out about 2 years ago. It's kind of the same thing, except in that case, the mediator has the ability to take a position and tell either party, I think you're full of crap, and if I were the judge in this case, I would make you pay all the legal fees. And that program is done primarily by a company called Dispute Prevention and Resolution here in Honolulu, DPR. And under that case, it's $175 a person. But the mediator's a retired judge, and they're pretty forceful. It's like a settlement conference judge, and he can express his opinion. And believe me, they do. And it's frankly highly successful to have an experienced judge talk to both sides and tell them the honest truth, what the outcome is likely to be in a court. And so on that note, because I want to talk more about facilitative or evaluative mediation, we're going to take a short break, and we'll be right back on more dispute resolution.
Aloha, I'm Christine Linders, a physical therapy specialist and the host of Movement Matters. My show is designed to teach you the simplest and most effective treatment strategies to get you out of pain and back to doing what you love. If you or someone you know is having pain in a certain area of the body and would like a free assessment in treatment over media or in person, and then come on the show to talk about it, email us at thinktechmovementmatters@gmail.com. Or if you have a topic you would like to know more about, please email us. My goal is to decrease pain all over the world, inspiring people to take better care of their bodies to enjoy life to the fullest. I look forward to hearing from you.
Welcome back. Again, I'm Richard Emery, the host of Condo Insider, talking about the guaranteed dispute resolution options all owners and board members have with respect to their living in their condo. Before we took the break, we were talking about evaluative mediation, because that's the newest, hottest, and most successful method used today and was enacted a couple of years ago. And I'm going to talk about this next slide and take you through it. Act 187, which was later amended by Act 196, provided for evaluative mediation. As I said earlier, the mediator can be more direct. It's normally a retired judge, and he'll listen to both sides. You go into each party in a different room. Mediator goes back and forth between the two parties. They kind of get a feel of the case. And the cost of this is $175 approximately per person. Basically, you have to pay 50% of the mediator's first hour of his time. The balance is paid for from the Hawaii Continuing Education Real Estate Education Fund, I guess is how I would describe it. So it's very affordable, and there is a cap on the amount of money they can put out. That cap can be extended if the mediator says he's close to a resolution. But it is a very affordable way to get a retired judge to hear this. And with people who want a resolution and are open to the truth, it's a very successful program. In the old days, when Act 187 was first adopted, it was strictly for governing document issues between the board and owners. When Act 196 was adopted, expanded who could participate. So it could be a board member versus another board member. That board member, you're accusing them of violating their fiduciary duty or their obligations. It could be the board versus a management company on some duty that's obligated under the condo statute. And so it's much expanded as far as who can do it. And even more so, you can voluntarily, both sides, has to be all the parties, agree to this binding arbitration. So you can avoid the process of what to do next, or do you have, because the mediation, at the end, you have to agree to follow what you agreed to say. And you can make a binding arbitration out of the gate if everybody agrees to it. But it has a very, very high success ratio. It's very easy to get done. You basically go to an approved provider. You fill out a form. It's about half of an 8.5 by 11 sheet of paper. Basically your name, your association, who the other party is, and what's your beef. And then it goes to dispute prevention resolution. They contact the other side and they organize both sides have to agree to the mediator, and they give you a list of retired judges. They set the dates, and usually these things can be done in a half a day. And it's such an easy thing to do. Let me see in my notes if I'm missing anything. No. Well, I think I told you already that this was about this expanded mediation with the parties, and the rest of it was about to sunset until the legislature in this past session extended everything I just said to you, and hopefully the governor will sign it or let it become law without his signature, because it's probably the most successful program as far as mediation goes. The next option beside evaluative mediation is rarely used, and it's called non-binding arbitration. What does non-binding mean? Well, it means you spend all the money, you hire a lawyer, you go to a formal arbitration proceeding, but at the end of that proceeding, after spending all that money, either side can say, I don't accept it, and file what they call a trial de novo, and it means it has to go to court. Well, the good of that is that you created a record in the non-binding arbitration. You can't use the record in the court, but you at least created a decision. If you go to non-binding arbitration and then you do a trial de novo because you don't like the results, and then they take you to court and you don't improve your position by 10%, then you're going to be obligated to pay all their costs to go to circuit court, meaning their legal fees or court costs, you may be liable for. Some debate on whether you have to pay their legal fees, but certainly all their costs and court costs, because you didn't improve your position, you didn't accept the non-binding arbitration, that you're going to have to pay them for not folding the tent on the first award. Very rarely used. I've seen it used once myself in the 25 years I've done this. So you can see that up until then, people have preferred facilitative mediation or regular lawsuits. It's kind of like, if I'm going to spend the money, why run the risk of having to do it a second time? Let's just file a lawsuit and that type of thing. Which leads me to the fifth option, which is you always have the right in America to file a lawsuit. And sometimes they will force you into mediation anyway. And then more times than not, they will. And then you can agree voluntarily to go to binding arbitration, which is kind of the same as litigation. The rules of evidence is a little more simple. It's a little more relaxed than the court proceeding, but you end up probably with the same retired judge you have in evaluative mediation. You get somebody who's going to be a judge and has got the same background and skills and experience. So in review, you have basically go to the board, facilitative mediation, evaluative mediation. You have non-binding arbitration, and then you can always file a lawsuit. The first one, board meeting with you, you have a right to meet with the board. And the next three, which is the mediation types and non-binding, are all in the statute. And the statute is very clear. If an owner makes a demand or a board makes a demand for mediation, and they have a fiduciary duty to go, and if they don't, it's a breach of their fiduciary duty. And that's only interesting because of the fact that if they were to breach their fiduciary duty and not go, we're not sure their director and officer liability insurance would protect them, because it's a willful intent, it's gross negligence. They're violating the law, so they have some real problems if they do that. So let's look at kind of what the core issues are. The next slide, what my experience has been on why we have disputes. I went through the bulletins by the Real Estate Commission and tried to generally look at whether they were facilitative or evaluative mediation. It doesn't specifically say, but you can kind of look at it and figure it out. And then of the evaluative mediation cases, what were the causes? And so I read those, and I basically did my best to categorize them. And 28% of the mediations in the state of Hawaii were related to whose responsibility is it to repair the unit. My door is broken, whose responsibility is it to repair that door? Because even the declaration, which defines responsibilities for components within an apartment and the common element, limited common elements, aren't always clear. And so you get into an situation where a pipe has jammed and caused all sorts of damage. What is the responsibility? Who has to pay for the pipe and how much? And who has to do that, including the insurance deductible? Because if you have a water claim, the board can assess the insurance deductible. So about a little more than a fourth of the cases had to do with the board having assessed an owner, or a repair needs to be made involving a unit, and there's a dispute and who thinks who should pay for what. And that's about 28% of them. The next highest was interpretation of the governing documents. And that's about 28% as well. So there was a dispute what the governing documents intent was, maybe what the board's authority is, all sorts of conditions that was a dispute and what the documents said. And an interesting case would be where an owner wants to make repairs to his unit and internal, and the board says, no, that's a structural wall. And what is that wall? And additional plumbing or adding AC. Interpretation of the governing documents was about 28%. Then house rule violations and fines, about 22%. They were fined for parking, or they were fined for something. And and they don't agree with it. And they go to the violation, and smoking on lanais is one that commonly comes up. You get all sorts of issues with regard to parking and whether they really did park, where they said they parked, et cetera. Next is maintenance of the common elements, which is 14%, where owners have filed saying that that the board isn't maintaining the common elements as required by the governing documents. Then there's unit owner delinquencies. Now, I want to just say briefly, you can't be arguing about the delinquency itself as far as your common assessments, maintenance fees, special assessments. But if you have fines or legal fees or costs incurred with respect to that, you do have a right to ask for mediation on that and try to resolve it, although that's very rare. And the final, I used to hear this all the time in the legislature, the board won't provide the governing documents, the contracts, the maintenance fees, everything else, and that's about 1% of the documents. But that's kind of how dispute resolution goes. So putting up the last slide, I'm going to circle back to self-governance. Remember, the boards have a lot of authority. Don't ignore communications and correspondence. Make sure you address issues with the board and realize you have certain rights as under the statute to resolve this peacefully through meeting with the board or some form of mediation or non-binding arbitration. So I hope you learned something today. We thank you for watching Condo Insider, and we look forward to you coming to another one of our Thursday sessions. Aloha.